Hi, Crime Junkie Jurors. Good morning. Make sure I'm not muted this time. Good morning. Good morning. Happy hump day. It is Wednesday, April 16th, 2025. We are ready for a big day. We have a motions hearing. Why do I hear myself? Oh, there I am. We have a motions hearing today. So, for those of you who did not see yesterday, the update, we have a jury. We have a jury. We have a jury. 18 total, 9 men, 9 women, and they are expecting to start. My lips are chapped. They are expecting to start openings on Tuesday. So, whoever sent me this chapstick, I appreciate it. And I didn't realize it's tinted. I can't remember who sent this to me. One of y'all. It's tinted. It's called Merlot. So every time I put it on, it's chapstick, but it feels like I'm wearing lipstick and I feel super fancy. All right. So we have 9 men, 9 women, 18 jurors total. They're doing a motions hearing today so we can tie up all of our loose ends, and openings will be on Tuesday. One of the reporters had said that they had asked if they wanted to start openings on Friday or on Tuesday, and they said they wanted to do it Tuesday. So the plan is, let me get you. I have some. It is with a heavy heart that I tell you that we do not have an only fan today. We have an only dome light. So I apologize for the boring dome light, but it could be worse, right? It could be worse. So that's what we've got going on today. I don't know how long this is supposed to last. This is basically going to be any of the final motions that need to be heard, any of the final decisions that need to be made. She very rarely rules from the bench. So more than likely, if this is anything like what it normally is, anything that needs to be discussed, they'll discuss it and then they'll adjourn for the day, and then she'll rule at a later time. A lot of times later today or tomorrow or Friday. So because Monday's a holiday. So that's the plan, y'all. We finally have a jury. Can you believe it? Does it feel like it was never going to get here? Kind of felt like it was never going to get here. Oh, dang. Hate the dome light. I know. I'm sorry. We got one of those old school, and it's like the old school brass one. It's not even like a, yeah, no only fan today. But, I don't know. There are worse things, I guess. I don't know. But that's okay. So at least we're here all together. I think we will lose a juror or two over the break. That's kind of how we're trending. We are trending to where we are losing jurors every time they come back, which is why, it's good. They're only going to have 12 that deliberate. And then there's going to be, of course, right now we have 6 alternates. So over the course of the next 6 to 8 weeks or 84 years, if we round up, there will more than likely be some that we lose. And over this few days that we have off, Thursday, Friday, and Monday, because it's Thursday, Friday, Saturday, Sunday, Monday. So there's probably 18 people sitting at home trying to figure out how to get out of jury duty by Monday or Tuesday. We may lose a couple more. We'll see. We'll see. Maybe they'll all stick around. There was there were a bunch of cameras following Karen Reed when she left court yesterday. She said she's very, satisfied with the jurors. They've been questioned thoroughly, that she thinks, she's satisfied with it. She's, confident. So we'll see. Oh, water. Gotta love water. Can we talk about the absurd theory Wendy Murphy claims Brennan is going with? I hope he does. I have heard, I said theory, not Siri. Leave me alone, phone. I have not seen it. I have had this sent to me about 11 times over the past couple days. And I started to read it, and I did not have it in my head and heart to make it through that. So I will look at that. I know it must be interesting because so many of y'all have sent it to me, but I haven't had a chance to really look at it yet. There's our only fan. Look, they heard us. They heard us. They got rid of the dome and they gave us our only fan. Big shout out to the camera guy. You're the real MVP. Now we feel at home. Now we feel at home. Love it. Love it. Hello, hello. Hello. Let me get my notes out so that we can keep up with everything that happens today. We got our normal camera person back. So hopefully we're done with the whole like overly zooming in situation. I wish y'all could see my office right now. I am surrounded in fur babies. I have two cats and three dogs. 3 cats and 2 dogs. I don't know. I have a whole zoo crew in here with me. If you hear snoring, it's one of them. Probably Tinsy. She snores the loudest. Yes, our only fan. So much better. So much better. Good morning. Good morning. Good morning. Good morning. Come on in. It's almost time for jury duty. We're just waiting. We need a zoo crew cam. I know. I need to figure out how to get it set up because in the condo, which I'll be in the condo next week, so we will have Lucy cam next week. The rest of the zoo crew will be staying here. Lucy will go with us to the beach for the week, but we have family coming to town. So Tuesday through Friday of next week, you will have Lucy cam because I'll be at the condo. But I got to figure out how to make like a zoo crew cam here because they're just all over. They're just all over. So I need to figure that out logistically because I know everybody loves the zoo crew. Everybody loves the zoo crew. Jordan Palm just started all your podcast episodes on the case yesterday. Really enjoying them so far. Thank you. Thank you so much. I appreciate it. I appreciate it. Yeah, it's funny because I was checking my analytics on that recently, and my highest episode listens are always like the most recent, like the most recent 1 or 2 episodes that are released. But like episodes like 1 through 5 are like right up there in the top this time too. So I'm like, everybody's, binging now before the trial starts. So Lucy girl needs her beach once in a while. Yes. And so does Lucy's mama. I am so excited. And I was really excited to hear that they're doing openings on Tuesday because I'm like, okay, that gives me like, most of next week when family's in town, I'll miss most of it because I'll be, stuck here for trial, or stuck there for trial, stuck in front of the computer for trial, I should say. But I will at least get a long weekend with the fam. So that makes me really excited. So I was very, very stoked, excited, grateful to hear that there's no court Thursday and Friday, and we, of course, are off on Monday. So same with the podcast, 24/7. That's my life now, and it's awesome, Brandi. Thanks. Summertime is perfect for our beach cam. Yes, and I will get. I can pull up the beach cam because I have that. Like it's just the camera that's like outside of our condo building, and it faces the actually, we can pull it up now. Let's just spy on the condo, shall we? Let's just look, see what they're doing. We'll just see what they're doing. Here's the oops, what is happening? Go away. There's beach cam. Spying on the condo. Look at that turquoise water. Oh, I love it. Not a cloud in the sky. So I'll be there Saturday, and we'll have a full week of beach cam. Got to check on the tiki huts, right? Oh, the freaky tikis. It's very kind of Bev took on it. Yes, I emailed her and I was like, look, Bev, I got family going. They're coming to town. I got family coming in. Can we just scooch this thing on over to Tuesday? She's like, yeah, girl. I'm gonna be at the Cape anyway. All of that was made up. There was no truth to that. Good morning, good morning, good morning. I also just listened to all the podcast episodes. I'm telling you, everybody's binging it right now. Good morning, Anne Marie Kenny. Hi guys. I've been following this case through Brandi since trial 1. Always thought John was found face up that morning, but Jennifer McCabe says in her call they flipped him over. So was he face down? That has been one of those things that has been kind of debated, but from my understanding, they found him face up. Karen Reed thought that he was choking where he had thrown up. She thought he was choking, so she was wanting to flip him over, but he was not flipped over when they got there. But what she said on the 911 call has been heavily debated. My husband just walked in and said, "What's that fan?" LOL. I said, "That's the only fan. That's the only fan." Yeah. Chat Daddy was listening yesterday. He had me on while he was in the truck and on the way to do whatever work. I don't know what he was doing. But he was on the way to a meeting. Actually, I do know. He had me on, and he was like, he texted me and he said, "You said OnlyFan. That's like a website." I was like, "I know. That's why it's funny. That's why we call it that." So funny. So funny. Good morning. Taste the biscuit. Taste the goodness of the biscuit. I just love that song. Emily, welcome. My friend told me about this channel and you in general. Here now and absolutely loving it, and the updates. Appreciate all you do. Thank you so much, and welcome. Welcome to the jury box. Welcome. I drove my son to Cincinnati for a baseball game and binged 17 hours of podcast 2 times. Wow. Oh, did you see any of the flooding in Cincinnati, like Newport, Kentucky, Cincinnati area? I've seen the pictures. It looks so bad. I used to live north of Cincinnati. For 6 years, I lived in Ohio. It was the coldest 6 years of my life. It is beautiful during the spring and summer and fall, especially the fall. Fall is incredibly beautiful. And spring and summer are too, but there's like a bunch of farmland around us and stuff. So there were all these like different pumpkin patches and mazes and stuff. Like fall was really cool. But fall is very short, and then comes winter, and spring is very short because it doesn't come until late. And it is 6 months of winter, and that was just too much for me. Too much for me. What was this? Yesterday, there was a why am I just now getting a notification for this? There was a shooting in Shooting in Dallas at a school. Wilmer Hutchins High School. I just got a notification for it. It says it happened yesterday, but it just now gave me the notification. I had not seen that. An arrest was made. Over a dice game? Is that what it was over, really? It's crazy. Good morning, come on in. Everybody's still filing in. We have, our hearing set to start, hopefully any minute now. They are supposed to be starting at 10 this morning. Say the 16th. Getting my little notes ready. Good morning, good morning. Come to Boston for a live podcast. I've never been to Boston. Never been to Boston. I will probably go after the trial is over, unless it's a hung jury again. It's too cold and windy here in Ohio, and we get all 4 seasons in one day too often. Yeah, that is true. What typically happens during these motion hearings? So this is where any of the things that both sides want, they basically come in, each side gets to plead their case. They have their motions normally that they've already filed. So sometimes they'll go back over some of the stuff that's in the motions, but they get to present case law that supports whatever it is they want. They get to make their arguments, their reasons. Whoever wants it is the first to go. Then the other side will get to make their argument as to why they don't think the other side should be able to get whatever it is they're asking for. Then the first side gets to rebut that again. And then sometimes decisions are made from the bench. With this specific trial, Judge Canoni very, very rarely rules from the bench. I think I've only seen her do that maybe twice. And every once in a while, they'll have things that there's no opposition for that, each side will kind of agree on. In that case, they're able to make the decisions. But normally, she will take it under advisement and then issue a ruling later. So any of the other things, all of these kind of last minute motions are generally kind of what really is going to shape the entire trial. Each side is trying to limit the other side's arguments, and they give specific case law that they say supports their argument. The thing with the judges, though, here's the thing with the judge, because case law is great. Both sides can give case law for separate arguments. But the thing is, it's up to the judge to be like the gatekeeper, is what she calls it, or what they call it. The judge is like the gatekeeper, but the judge has a lot of discretion. So it's kind of like they can both make their case, and then she makes her ruling. And either of those rulings could, a lot of times, under the law, be acceptable rulings, but it's up to her to make those. So you will see sometimes they'll have very similar arguments in in different trials, and the judges will have such different styles that you will see sometimes very, very, very similar arguments and 2 judges ruling 2 different ways, and both of them are acceptable under the law. And the reason for that is that they have discretion to make decisions based on what they feel is the best decision under the law in their courtroom. So it's kind of like if you go to, mom and dad and plead your case for having, ice cream after supper. One says, yes, normally, and one says no, normally, and they both have their reasons for it, and both reasons could be solid reasons. It just depends on which one you go to. So that's kind of how judge's discretion works. Some things are very black and white under the law, and are not allowed and are appealable issues. So like if you say, if you have like prior bad acts, for example, that's one thing that is very rarely allowed in. Things that will bias the jury, like, or prejudice the jury against the defendant or a witness or whatever, things like that. There are a lot of things that are kind of a lot more black and white, but so much of the legal system is in the gray area. So the judge basically is the one who makes the decisions for everything in the gray area. So that's what they'll do this time. They'll plead their case, make their arguments. There will be snark. There's always snark. And then the judge will take it under advisement and give us a decision later. So that's what's happening. Snark and heavy sighs. There will be heavy sighs. If there's two things we can count on in these hearings, we can count on there being some kind of snark, and there are going to be heavy sighs. So those two things will definitely happen. Good morning. Good morning. You're on time. We've been waiting for you. You're only on time because they're late, though, Jackie D. And that's okay, too. That's okay, too. Oh, where'd that go? Oops. So can the fact that Proctor was fired, can the Commonwealth fight as prior bad act? No, but okay, so I expect to hear about this today, because this is one of those things that Brennan had said before in one of the motions that, or in one of the hearings rather, that he was going to file a motion on this. Remember, they were arguing about this before Proctor actually lost his job. Now, Trooper Proctor is former Trooper Proctor, so it's a little bit different, because all of the things that they were arguing over were, or a lot of the things they were arguing over were hypothetical. Like if this happens, if that happens, whatever. And then a lot of things they were arguing over were part of an investigation that had not been completed yet, right? They were still in the process of going through the hearings and trying to see, if, will we be able to get this, will we be able to get this information and give it to the jury? That's a lot harder when the investigation is not complete. The internal affairs investigation, or, them looking at Proctor, the Massachusetts State Police Board looking at Proctor. Now it's done. Now he is officially former Trooper Proctor. So it puts a whole different perspective on this, because now they have the results of this. It's not just, oh, they're investigating this. Because here's the thing, if the reason they don't obviously let things come in when it's still under investigation is because, let's say it's under investigation and then they get to the end and they're like, no, nothing was done wrong. Not with Proctor, because obviously we heard those texts, y'all, but just in general, if somebody is being investigated and you bring that up to a jury, the jury is going to be like, oh, they're being investigated? That's bad, right? That automatically will make you question credibility a lot of times. But if they are being investigated and then you hear that, you question their credibility, it changes how you think about things, changes how you process the information. And then at the end, after trial's over and we've all gone on our merry way, then they find out, oh, well, the investigation's over and they didn't find anything. There was nothing that, these are all false allegations and nothing that he did was wrong or whatever. Then it's too late. That damage is done. So if something is still in the process of being investigated, that's generally why it's not acceptable for it to come in. But this one is over. They did find what he did wrong. He lost his job over it, and the defense is wanting to use that for good reason. Because look, the defense has been saying all along, their issue with Proctor is that he showed bias against Karen Reed and got tunnel vision and just went for her right from the beginning. That's what the defense is saying. And now here the state police are like, yeah, he showed, like there's perceived bias. We see this. Like he did not perform his duties the way they're supposed to be done. We see, you know, bias in this. You got to go. That confirms what the defense has been saying. So of course they're going to want to use it. And of course the Commonwealth is not going to want them to. So Brendan had said in one of the hearings before that he wants to limit, exactly what can come in, what they can use, what they're allowed to say and what they're not. They don't get to just come in and say everything they want to say. So Brennan prosecution wants to limit that. So we might hear from that as well today. So. Yes, dishonorably discharged. He is considered dishonorably discharged, and he is now former Trooper Proctor. Will the jury be aware he lost his job, or will that be kept from jurors like other things in the first? I don't see how they could possibly not be told that he lost his job. I don't see any way for them to be able to keep that out, especially because he lost his job for conduct related to this case. So we'll see. Didn't the internal investigation find no wrongdoing? No. No. The internal investigation, I've tweeted the report, but they did find wrongdoing and he lost his job over it. Bookbug for Life said, I wasn't going to watch this trial again because the bias of the prosecution and judge infuriated me, but maybe I'll stick with it. I like this community. I'm glad you like this community. I love this community as well. But I will say this too. This is going to be a very, very different trial than the first one. We have a different prosecutor. We have 2 new additions to the defense team. We have a whole different strategy, and there's new evidence. So this one will not be focused on just snow and high top tables. This one is going to be a very, very different, a very, very different trial, very different setup, very different strategy, just very different everything. So we'll see. Jackson starting cross. Good afternoon, former Trooper Proctor. You know he's going to really hammer in on that. Good morning, good morning, good morning. Christina Rex just posted that the hearing is running late and will start at 10:30. They're always running late. I think it's misleading that they classified him as Trooper Michael Proctor since he was fired on the witness list. Yes, however, they have him as Trooper Proctor on the witness list. He is now former Trooper Proctor, but keep in mind too, the witness list is only when it's being read in this capacity, like the combined witness list, it's only to see if any of the potential jurors actually know or have any kind of conflict with him. So it's not I know a lot of people were mad about that, especially after some of the gross things he said. But just keep in mind for that specific purpose, it's only for the potential jurors to hear so that they can decide, or they can hear it and it can, they can figure out if they have any kind of past with him, if they know him, if they, whatever. So, but when he's up there on the stand, you can bet that the defense is going to make sure that there is no confusion. So. Good morning. Good morning. Still can't get over having new evidence after she was already on trial, right? That part. That I don't understand that either. I don't understand it either. I don't understand either. I think the witness list was technically submitted before he was even filed. I think so, yeah. Even if the final one wasn't, he was, because I know that there were some additions toward the end, but he was one that was on there from, from the beginning. Good morning. Good morning. Curious as to why there hasn't been an emphasis on how there was no frostbite on John O'Keefe and the body temperature being higher than you would expect if he was out there for 5.5 hours. Yeah, I know that. I mean, with all the different medical examiners that we've had up there, um, I know that, body temperature is one of the things that they testified on, but I can't remember exactly what it was. I have it in my notes from my other spreadsheet. I think it was like 80-ish something. Don't quote me on that specifically. I'd have to look it up. But that is something that a lot of people have wondered about the body temperature. Hello, hello, Tegan. Happy to be here. It's my first time actually watching this live since I'm 3 hours ahead. Welcome, welcome, welcome. Especially the new Sallyport video. That's the part I can't understand. It's like all the new Sallyport video, like falling from the sky. I just don't. I shouldn't more Sallyport videos turning up be a Brady violation? Again, this is like a gatekeeper thing. I think so. Most of the attorneys that I've talked to pick their brain on it think so. The prosecution's argument is that it's not a Brady violation because they say it's not exculpatory. I think it falls under what's considered exculpatory because exculpatory is basically, going to be something that helps your case. And that video, I guess it's how you interpret that. But, to take it as the Commonwealth is basically saying like, well, it's not like you can, see Proctor over there banging the tail light and breaking it and taking pieces and planting it. No, of course that's not on there. That would be an obvious Brady, violation or obvious exculpatory evidence. But the defense is saying it doesn't have to be that for it to be exculpatory. It's still stuff that supports our theory and shows, that what we're saying has some meat on its bones. And so that's where the discretion of the judge comes in because, it's up to the judge to say, does this meet the requirements for being exculpatory? Does this make it a Brady violation? And if it's in one of those gray areas, you just have to rely on the judge to tell us, what she decides. 80 degrees. Okay, so I thought it was around 80-ish. Karen is at all of the hearings. Karen has been very, very involved in her defense. She is they've said in some of the interviews that she is, I think Alan Jackson said, was it the Ted Daniel interview that Alan Jackson said that she, out of all the clients he's had, she is the most involved in her own defense, and she has a very analytical mind. So she goes through everything with a fine-tooth comb, is very involved in it. You can see her talking to the judges, or not the judges, talking to the attorneys a lot during the hearings and even during the first trial. She's very involved in the going over all of the evidence, going over, strategy stuff, going over the thought process behind, the way that they approach different things. She's very, very involved in all of this, and she's been at every hearing. And even with the jury selection, she wanted to be able to be there for sidebar to be able to hear what they're doing. So they ended up having her. She didn't want to be standing up there for sidebar because there's already so many people up there and it kind of gets clunky. But they ended up putting her in a seat right behind where they were doing their sidebar so that she could hear. She's not participating, as in she's not up there asking jurors questions, obviously, but she wanted to be able to hear. So she was up there so that she could hear. So very good odds more video will be found after this trial based on what has been found so far. They downloaded it in 6-hour chunks. So they've had it all along. I don't know why we spent so much time arguing over if it should have been preserved or not, because it came out, it was preserved. We know it was preserved. Why did we keep arguing over why it didn't need to be preserved when it was preserved? That's a moot point. But I think it was just a red herring. I think it was like something to distract everybody from, like, the fact that they had it all along and never turned it over. But they have those, they preserved all of those 6-hour chunks. So, or preserved all that video and put it into 6-hour chunks, I should say. So I don't know why it wasn't turned over. But that's another one of the issues here. Proctor put some of that in the file and then just never turned it over. What's happening today in court? We have a motions hearing. This is the final motions hearing before we actually start with trial. So this is kind of all the last minute arguments on who wants what. They can plead their case, and then openings are supposed to start Tuesday. What do you think happened? If it was up to you, how would you rule? What do I think happened with which part specifically? Like what happened to John O'Keefe? Here's my thing. I don't know. And if I don't know, that's an automatic not guilty, because the case has not been proven beyond a reasonable doubt. So if I still have questions about what could have happened or who could be responsible, that's a not guilty. So it's not up to me to solve the case. It's up to me to weigh the evidence, dissect it however I dissect it, take a look at it, see what makes sense to me and what doesn't. And there's so much about the prosecution's case that just hasn't made sense to me. There's so many questions and holes in what they've presented. And because of that, it has not been proven beyond a reasonable doubt to me. And it's a not guilty for me. Have you talked with Dr. Kinsey after Brennan quoted your interview with him? Yes, actually, right after it happened, I texted Dr. Kinsey and I was like, just so you know, we have now made it into a courtroom in Dedham in Norfolk County, Massachusetts. Very surreal moment. Does the jury get to hear the motions or only when the trial starts? The jury does not hear the motions. So all of this stuff is done outside the presence of the jury, because the whole point of this is to get to decide what the jury will hear and what they won't. So they plead their case about why the jury should or shouldn't be able to hear this outside the presence of the jury. And then And then once the judge makes her ruling, then we know what they're allowed to hear and what they're not. Feels like it only came out because of the audit, which is a whole nother issue. That's one of the I'm assuming we're talking about the Sally Port video. That's one of the things that has been a big problem with me too, because think about if we weren't having to do a second trial, we would never know that all of this other video evidence existed. And that's a problem. That's a big problem. Mike says, bingo. I just don't get how more people can't just boil this down to its simplest form. We don't know what happened. I think that's one of the big things too, is that having a third party culprit defense has kind of done this big burden of proof shift to where I think a lot of people are going into this thinking that you have to either choose one or the other. Either Karen did it or the defense's theory is right. And it was, Brian Higgins, Brian Albert, and Colin Albert. You don't have to pick one of those. Your choices are either Karen did it or something else could have happened. Those are your two choices. Now, the defense is giving you an alternate scenario of what they think happened. They're giving you the evidence that they have that supports their theory. The prosecution is giving you the evidence they have that supports their theory. Keep in mind, both sides are looking at all the same evidence. They're looking at all the same papers, all the same videos, all the same statements, all the same reports, all the same everything. And they are looking at all of this evidence and coming up with two very different scenarios for what happened. They're presenting it to the jury. They're giving the evidence that supports each of them. And it's up to the jury to decide what they think happened. Now, the thing with the third party culprit, though, like I said, sometimes that does shift that burden of proof, even though it's not supposed to. So sometimes people will look at that, which is so common on social media. I've noticed so many people think that you either have to choose between Karen or the Alberts and McCabe's. That's not it at all. It's either Karen did it and there's no reasonable doubt that she did it, or there is another reasonable explanation for what could have happened. I don't know what it is, but this one does not seem like, this is not ironclad for me. It does not seem like the only reasonable thing that could have happened. And if you're there, that's a not guilty. It's not one or the other. So I think, it's a good thing for a jury to have an alternate theory from the defense. If evidence points towards anything else, I think it's great. Let the jury hear everything and let them decide. But also, I think that in this case specifically as well, because tensions are so high in this case, I think that it has made this whole situation into an A or B. You have to choose A or B, and it's not that at all. It's either A or something else, and that's it. It's not really A or something else. It's either A or maybe it was A, maybe it was something else. It's either you know it or it's not guilty. Those are your two options, and I think that that's getting lost in a lot of this. Does anyone think, should we have another mistrial? Would there be trial number 3? Yes. I don't think they're giving up on this. I think that this has now become personal to Norfolk County, and I don't think that they're going to give up on this. But that's just me. I think that if nothing else, they have way overcharged. I don't to try to do a prosecution based on a murder charge for this is just wild to me. I think their best, and this is just my personal opinion, y'all can let me know what you think. My personal opinion, I think that's way overcharged. I think that, if they did anything, I think they could present their evidence for the manslaughter, which is the one that the jury was hung hung up on the first time with the different lesser charges under manslaughter. But murder and like the whole murder motive, was just like an argument in Aruba a month earlier. That was just nonsensical to me. So, good morning. Good morning. The jury admitted they were coming up with ways John died in deliberation, but they all agreed Karen was drunk, so she must have. So frustrating. That was one of the hardest things for me listening to the juror interview, because I was like, that is not how this works. And what that says to the defense now, that does give some insight to them, because I think it gives them an opportunity to say, whoa, maybe we need to really hammer down on what their job is to do, what they're looking for, what the law is, and go from there. I did an interview with Reb Maisel. She's amazing, hilarious, funny, smart. She's an attorney. She was, saying the same thing. I had asked her, what strategy would you use for this? And that was one of the things that she said, really hammer home on the reasonable doubt, and the jury's job is to decide, is this charge proven beyond a reasonable doubt? It's not their job to sit back there and decide, like, well, maybe this could have happened, maybe that could have happened, but she was drunk, so she probably did it. If you're saying maybe this could have happened or maybe that could have happened, that's an automatic not guilty, because you're not firm in this is what happened. And I think it's very eye-opening to hear that coming from a juror, because it really shows their lack, this is not a dig towards the jurors at all. I can't imagine being, a juror. Yes, we are 13. Well, we are 13 jurors, crime junkie jurors. We are all those jurors. But to actually have to sit in a courtroom and not be able, because we get to sit here and chat and gab and laugh and all that kind of stuff. Go through the trauma together, go through the funny stuff together. Like, we get to do all of this together. They don't get to talk about this. They don't get to work out, like their thoughts and all that as they're weighing evidence. They have to sit there quietly for 8 weeks and not talk about it to anybody, and then all of a sudden make a decision. So I'm not taking this as a jab towards any jurors at all, but it is a little bit alarming when you hear them in interviews saying that that's what they were doing, because that's not what the instructions are. So, I think that that's something very important for the defense to really explain this go round. So, hello, Sabet. The cops lied to the police auditors about the cameras in the Sally Port. They were replaced after, and Canton said they were saying. So I put this in the latest podcast episode. In the hearing, Alan Jackson reads from a report that says that the inverted camera was replaced by Louis Jutras sometime between whatever date it was and then this date. It specifically said that that camera had been replaced. And then when I watched the audit hearing and somebody from the crowd asked that, the auditor was like, no, it has not been replaced because of the ongoing prosecution. So that's a problem. That's a big, big problem, because truth was not given. Those are two very specific things. Those are not like, oh yeah, I think we replaced that. I think, yeah, we replaced that. We replaced a few of them. I don't know. That's not that. Those are two very specific answers, and they're two very different specific answers. So that's a problem. So I'm curious to see what comes of that. I put that in the last podcast episode because I did notice that. Crazy. Helena J says, I don't trust the blood draw. Most states have a 2-hour window for drunk driving blood draws. This blood draw was 7 hours old. She may have been drunk, but 7 hours would be tossed anywhere else. Yeah, that one would be tossed anywhere else because of not just the timing, but also keep in mind, this was not done. The blood draw was done through the hospital. It was not done through the state police. It was not done. So basically, even in the report where they did the extrapolation, and they, did their estimate on their blood alcohol estimate range where they thought, well, she could be somewhere in this range during that time. It even says on that report, this was not done to be like, it does not have the accreditation of the Massachusetts State Police Lab because it wasn't done with the standards that they have. So normally when we see things like that, those things are not allowed in at trial. This one is, but it's something that instead of excluding it, she has allowed it in, and they've tried to keep it out of both trials. And it has been allowed in, it was allowed in, and basically that was just used in cross-examination. But here's the thing with a lot of jurors that we see. People, and even you'll see people saying, oh, well, her blood alcohol was this and this and this. People will hear, it doesn't matter what they say on that cross-examination. For some people will hear that blood alcohol content level and they think, well, that's science. That's what I'm stuck with. And then they stick with that number and they internalize, like that is set in stone. This is what happened. And they're not taking into consideration all of those things that were brought up on cross-examination of why that normally wouldn't fly, why it's not, why it has such a big range, why it's, why there's so many variables that could make it not as, what's the right word? Make it not as reliable, I guess, as if, it had been done properly by state. Not that it wasn't done properly by the hospital. Hospital did fine. That's not the issue. It wasn't done by forensic protocols from the Massachusetts State Police. It's not something that would be used normally in court proceedings because it wasn't done through the accredited lab and process that they use specifically to do things for criminal trials. It was done through the hospital, and that's why. But isn't that interesting, though, how people will hear that part and not understand or hear or listen or interpret or bother with any of the rest of it? So, I don't know. Good morning. Good morning. Better late than never. They're late as well, so you are totally fine. Yeah, they were told not to speculate, and then they went and did just that. All right, the hearing is finally starting. They are about to get going, allegedly.
You are unmuted.
We are unmuted. Y'all can hear it?
Yay, yay, yay. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Brennan.
Okay, I'm going to pause for just a second. So if y'all aren't catching this, this is for the metadata, the forensically sound copy of the metadata and the Sallyport videos. They're wanting their expert to go just look and see. She said the damage is done. There might not be anything, but they just want to be able to send an expert out there to look at the computers. Since they argued this the last time, because she's asking for the judge to reconsider this. Since they argued this the last time, she's saying that they have gotten that report from the retired Sergeant DGM Pietro, who said that he downloaded all of that video from January 29th. So before, when they were arguing over, well, was it, preserved? Should it have been preserved? Did Unetti ask for it to be preserved? Yada, yada, yada. None of that makes sense. DGM Pietro said, yeah, I got it all. I put it all on there. So now they're asking, can you, reconsider this and let our people go check to see if there's any kind of metadata so that we can confirm the validity of all this.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed, and then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department Detective file? Because we've been in our request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view, she can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously, the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team
Is that better?
to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed,
That's
and the
fine.
rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they
They
decide,
want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anyway?
All right. Skip for those few seconds. So this is about the view. Remember during the last trial, we had the jury. There was one day where the jury went to view the yard at 34 Fairview, and they had the SUV out there, Karen's SUV out there, for them to look at as well. This time, the defense has asked for Karen to be able to go as well. So the judge has said, yes, that's fine. She can't ride in the bus with the jurors. Obviously, so they just have to figure that part out. And Brennan had said that he didn't want the car there last time, right? Because he said that, I have to pull it back up. He had said something about the it not being the same conditions, like the same weather conditions or something, or whatever whatever his reason was. I remember thinking like that doesn't make a whole lot of sense. Let me see if I can find it real quick. Yeah, the conditions wouldn't be the same. That's what I thought, because I remember thinking that doesn't make sense. He wanted the car to not be there. And that was kind of one of the things where they were like, the whole point is to see the car and the yard and see the size and see kind of figure out how this all could have worked. The snow doesn't really make a difference in any of that. So that's not really the whole point of this, but whatever. Oh yeah, here it is. It was from the March 18th. Brennan doesn't want the car at Fairview, says it creates an image that isn't accurate because it's different lighting conditions, weather conditions, etc. Miss Little says it should be there so that they can see it at the same time. Plus it keeps them from having to arrange another viewing. So, and I remember I even made the note. I was like, I don't think that will be denied because Judge Canoni is not going to want to have to schedule 2 viewings. She's not going to want to have to logistically arrange for the jury to go to 2 different places to look at the car once and then the yard once. Yeah. She allowed it last time, but she keeps saying, this is a new trial. This is a new trial. And this is a new prosecutor, so he's objecting to things that weren't objected to before. But I don't foresee this being something that they can, or that she'll object to. So we'll see. Brennan wants them to get a snow machine and a solar eclipse. Yes.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it. And that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay.
I will do that.
All right, thank
Thank you, Your Honor.
Okay. So Lieutenant Wing,
This is Garrett
docket
Wing.
607 and 658.
This is the dog
So
guy.
what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
It wasn't the defense that was saying the thing about the medical expert. That was Judge Cannoni's ruling,
Thank you, Your Honor.
specifically Judge.
With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right,
Okay.
that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites two specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with the wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing with regard to Lieutenant Wing. Again, Your Honor will make that judgment when the court looks at his report. To the extent the court believes that notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear next.
Understood. And I was just going to say, I am not going to get into the basis for that. I just wanted to, because
Just go ahead, just move on.
Yeah, so my request would be that a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion with regard to Dr. Crosby. So in conclusion, Your Honor, we respectfully request that the court deny the request of the Commonwealth to have a voir dire hearing on Lieutenant Wing. At a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right, so there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
Substitute chemist, they have.
No, Your Honor.
Okay, so Jim 63 is allowed.
They have the chemist who came for the first trial is medically unable to come to this trial, so they just have somebody taking their place.
Yes, Your Honor.
No big deal on that one.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Heard it so much.
Okay.
Methodology.
Who's arguing this for the defense, or who's telling me what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right, I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
Just a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay,
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay,
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes.
give
We'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that.
So this is just for the openings. The defense is going to use a picture as a visual aid for the jury, and the prosecution is going to use some recorded statements from some of Karen's interviews.
Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes,
So,
please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
But we could have somebody playing clothes from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
May I have a moment, Your Honor?
Yes.
So they're he's wanting to have an independent reader. So somebody to go up there and read the text messages for people who aren't there. The other ones, I didn't want to interrupt. So we'll go back over them at the end. We'll kind of do like a little summary on all this stuff. I'm trying not to.
Read at the last trial, they simply came in through the person that tended to be, which I don't think we're in a time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly as a police officer, I think is creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Garino is the one who found it, he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be. And the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between
agree
two
with that.
independent people with motives that may or may not be consistent with the text messages.
I agree with
As we
that.
all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps, not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you. All right, defendant's motion for specific discovery, paper 638, Jimmy.
Real quick, my issue with that one is that we've seen how theatrical Brennan is with everything. And so my trust level with his presentation of things is automatically like, and I say automatically, it is not automatically gone. It is gone because of what he's done before. So I think that this should be like it is in every other trial, and the person testifying to them should read them. But what do y'all think?
All right, who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay, I'll hear from the Commonwealth.
Number 5? Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses, motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to their February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my 3 requests.
This has been an ongoing feud between them.
I want to go in reverse order briefly, if I could. Concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate there too. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we...
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. That's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but...
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13, another party says, we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point, that this is not responsive. Their discovery deadline has passed. And so I would like to talk about, or respond after Attorney Jackson is done, about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected, might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is. They
So
desperately
address
does
number
not want
one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th, about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better?
They went over all that.
They said
though.
we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rentschler talked about what he did, which was more on the biological side.
There was a difference between the
and
two.
Dr. Wolf talked about what he did on the mechanical side.
Yeah.
They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult counsel just for a moment?
Sure.
So Brendan keeps saying they don't have all the text, and Jackson is saying, yes, they do. We've turned everything over.
Right. Ms. Liu I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government, the Department of Justice.
But can
So-
they testify as to what they did?
Yes, that is on, that's
Can
on the
they
table.
testify under what direction they did these things?
They've already done
Well,
that.
they can certainly testify to what they did, absolutely. That is on the table. Every bit of testing, every bit of analysis
But
that
why they did it?
what their communications were, what their directives were, that is confidential. And
Can I see Counsel Tagbar, please?
So I don't I don't know what more clarification they want on this. This is something that they went through very specifically. I probably still got the clip saved on my computer where I've used it in multiple podcast episodes. They were very specific about what they were told to do and what direction they had. They were told to, I can't remember the exact words he used, but it was very, very simple. They were told to determine if, there is any relationship between the injuries to John O'Keefe and the damage to the car, and if one could have been caused by the other, or however he worded it. I don't know what else they could possibly want. Honestly, it feels like all of the things that they asked last time, like when she said, who did what on the clarification, they were very clear on that. Because that was questioned last time during voir dire and during their testimony. So this is stuff we've been through. So I'm not sure why we're back here again, talking about it again, but yet here we are. All right, we're live now. We were about 10 seconds behind. It feels like we keep going back to this, and I think that every time we go back to it, we seem to go back to it with some of the same arguments and a new twist on the old arguments. It seems like maybe they, I guess if they don't want ARCA to testify, because for most of us who watched it, we were like, okay, that made sense. The things that they said, the way that they explained things, the way that they were able to confidently give their answers and explain how they got to those answers, why they got those answers, that was something we could hear and accept because it was logical and it made sense, and they were really great at explaining everything. Then you go to Trooper Paul, for example, and he was not able to explain why he came to the conclusions he came to. There was no explanation of, yes, this is how I got here, or this is what, like the answers that he gave, like it just does was one of them. Like, how did the phone get under Officer O'Keefe? Well, how did it travel with him? It just did. Stuff like that. Those are not answers that we can hear and explanations that we can hear and say, all right, I got you. That makes sense. I can see how you got there. Whether or not you agree with them, if you understand their testimony of how they got those answers or how they got those conclusions, that's pretty powerful stuff, right? Now, in this case, we heard from the jurors who thought that because they weren't allowed to know who hired ARCA, they thought that they were hired by like the insurance company or by Karen Reed's family or somebody who was basically just trying to trick them, that had ulterior motives. And that's why they were testifying for the defense. So the jury, who's not supposed to speculate, spent a lot of time speculating. And because of that, didn't take some of that into as much consideration as most of the world did who watched it. But I think that those were two of the most, which the defense didn't bring up many witnesses. What was it, like 5 or 6? There weren't many witnesses, but those two, the crash daddies, were two of the most powerful because they were very confident in their answers. They were very credible in how they explained things. And, you know, obviously ARCA is a very credible company, and they built a cannon. So there's that also. I think it would be a huge issue to exclude ARCA because that is exculpatory evidence, because the defense didn't hire them. This isn't like the defense found this expert and now the judge isn't letting this expert in. They were hired by the federal government. So the report that was handed over to both sides is exculpatory evidence. So excluding them would be a huge deal, a huge problem. So I think that it's something they keep going back to. You know, Brennan has said that he doesn't have any issue with, he says he welcomes their testimony as long as he can get his discovery, but then he kind of keeps moving the goalpost on what that discovery is. So I don't know, we'll see. I think Brennan is still digging for a connection between ARCA and defense. He's hoping for an aha moment and info that the feds won't allow. I feel like that's exactly what it is, because he keeps saying, you know, he wants all the emails and all the text messages. And he has said multiple times that, you know, oh, they had to have talked more. And Jackson is saying, we have turned over all of the emails and all of the text messages. You have all of the communication. There is no other communication. And so then Brennan came back and he's like, well, I want a report on every phone call, you know, that was made and what was said. And I want, you know, the emails and text from the ARCA experts. And I want to talk to them about the relationship between y'all. And Brennan is obviously like not trusting that the defense has turned everything over. And it sounds like he's hoping to get something that they didn't turn over. Because remember, that was his big aha moment in court that one day when he was like, oh, the federal government gave us this, the defense didn't. And then that's when the judge, that was like the ARCA stuff, and that's when the judge had grave concerns. We had to call up the whole day. And then it turns out he was wrong. The defense did turn that over, not ARCA. So I think he's wanting that moment that he made by giving false information. I think he's wanting a real life one of those, and he keeps pushing for it. So we'll see. We'll see what happens. The ARCA argument just never seems to end. Yeah, Turtle Boy, aka Carney, is there. There is a motion from him who wants to be excluded from the sequestration order. Same as Gretchen Boss.
All right, so Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into its desk.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA
Do you
to
know?
answer their questions.
Do you know what information was provided?
Yes, it's in the report. There
All
are
right,
14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then
from
you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when
that's
did you
what we
do?
provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Let's take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said, I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right,
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
all right. Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provided a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information and reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November. And then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welcher's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
That's a
According to Mr. Alesi, who is much more facile with the facts of what's in Judd Welcher's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judd Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there is no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you. I think is the only thing left the motion to sequester Aidan Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to...
We've had a chance to review the file. If there's any statements that are relevant, We think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right. So I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number on what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
All right. So let's break some of this down. All right. Let me scroll up and see. I've been taking a few notes while we were going over this stuff. While we have a 15-minute recess. All right. So the poll that I have up right now is, do you think that ARCA should be allowed to testify? Now, here's the thing. This has been one of those situations where we keep going back to this, and I promised y'all at the start of the day there would be snark, and the snark came during ARCA. No surprise there. This has been a big point of contention between them. It's like Brennan just said that, let me find where I typed this down. I was making notes as they were going. He believes there will be info that ARCA has, and he wants the court. He says, if you order them to bring in all the emails, phone records, etc. He says he's entitled to see that. He believes that there are going to be communications that the defense didn't turn over. He wants to catch the defense in this entanglement with ARCA, and it's like he truly believes that he's going to be able to find something if the court orders this. So he doesn't want ARCA, he doesn't want them to do the voir dire the day before testimony, because he's like, no, because if you get them here the day before, then I can't say, hey, you need to show me all of your texts and phone calls and communication with the defense, because if they're already here for the trial, not here, they ain't coming to Florida. If they're already there for the trial, then they won't have all of that stuff. So he wants this to happen beforehand. The feigned indignation, not based on fact. I told y'all there would be snark. They are very, this is one of those arguments that it seems like it's just, I don't honestly really understand what else they're looking for. Because even some of the things that they're saying, it's like, I'm tired of hearing about this. I'm tired of hearing about, well, we don't even know what they looked at. Yes, you do. Yes, you do. It's in the report. It's in the voir dire. It's in the testimony. It has been, that horse is dead and beaten and gone. You cannot beat that horse anymore. This has been discussed. We know exactly. There's a very specific list of what they were given. This is not new experts that we don't know anything about. We know what they used for their report. We know what they looked at. And as far as the report saying we did this, they also talked about that in the last trial. They talked about what each of their focus was, but that they all did the experiments and testing together. So they're doing these, experiments, they're doing this testing, but they're looking for specific things and they have different focuses on what they're looking for. So yes, the report might say we did this, but they were able to testify during voir dire and the last trial about what it was that they were looking at and about what they were told to look for, what they were told to do. And the argument about, well, they weren't given everything. The U.S. Attorney's Office and the feds didn't want them to have everything. That's the whole thing. Here, okay, look at it like this. If you are taking this, there's this debate going on, everybody hates everybody, everybody's mad at everybody, everybody has two different theories about what's happening. And the whole thing comes down to, did that car hit John O'Keefe? Or did something else happen? Did that car hit John O'Keefe? That's all you want to know. Then you take the information that they will need that is relevant to finding out that. They don't need extrajudicial statements. They don't need, one of the things they made a big deal about was the DNA on the taillight. Yes, there was DNA on the taillight from John O'Keefe and also two other people. So that's not something that even has any relevance to, did this car hit John O'Keefe? Is that what caused the injuries to him? Is that what caused the damage to the car? That's just muddying waters. You need one specific thing. You need to know one thing. And that's, was there an interaction between Officer O'Keefe and that SUV? That's the one thing that they needed to look at. So they were given the exact information that the U.S. Attorney's Office and the feds wanted them to have in order to find that one thing. Not all of the outside noise, not what supports any other theory. The crime scene pictures, the whatever it is, like the 11 or 14 things, whatever it was, the specific things that go to that one question is what they were given for a reason. All of this other stuff is noise to try to distract from that fact. That's how I perceive it. If y'all perceive a different way, let me know. Tell me how you see it. I'm always open to hear other sides. But every time this has been gone over through all of this, it has been broken down and we have gone over it and over it and over it and over it and over it. And it's almost like if you keep asking the same stuff, maybe somebody will slip up and say something that you can, I don't know. It just boggles my mind how we keep revisiting this. It really does. And the theatrics behind everything is, keep in mind, the theatrics are not even in front of a jury. We don't even have the jury in there. Think about the theatrics that are going to be coming in the next 6 to 8 weeks. If they, whoever, anyone involved, is already being very theatrical in the courtroom and there's no jury to be theatrical for, imagine how it's going to be in front of the jury. Right now, it's for the cameras. Right now, it's for the public. Think about how it's going to be for the jury. I'm going to be muting my mic a lot during this trial. I can already tell you that right now. I'm going to be muting my mic like, oh my gosh, give me a break. My snark will be showing. Also, I will give Judge Cannoni some props on this part. When Brennan said, you know, oh, they could have had ARCA in November. We had, you know, we gave them discovery in November, however he worded it. I'll say this, Judge Cannoni was like, okay, so are you saying that you gave them the report in November? And he had to come back up there and he had to correct himself. He had to correct what was said because he's like, well, I gave the CV in November. The CV, the curriculum vitae, that is totally different than giving the report and the information and the conclusions and all of that stuff. That's just like, hey, here's this dude and all of his qualifications. That was given in November. So having him come up and have to clarify that, which he has to do a lot in court because he gives a lot of misrepresentations, which is one of the things that one of the reasons I said I have no faith left in him as an attorney. I'm not a fan at all. Some people may love him. That is great. I personally am not a fan because once you have crossed that line too many times for me, I'm not a fan. I should be able to trust that an attorney is being truthful when he's saying something up there on the record. And when it's happened so many times that he wasn't, that for me, I've now lost faith and you have to double check everything and fact check everything that he says. So what's Judge Cannoni do? She fact checks him. And then he says, well, no, we gave the CV in November and then the discovery January 31st and then the rest of it in February. So, and that's it, which is exactly what Jackson had said. So then he gets back up. He's like, he just admitted that it wasn't until February 5th that we had all of Dr. Welcher's info. So Dr. Welcher is kind of like the prosecution's version of a crash daddy. So the defense attorneys, or the defense has the ARCA experts as crash daddies, not because they found them, not because they hired them, but because the feds hired them. The conclusions that they made support the defense's theory, not the prosecution's. So the defense was like, hey, I'm gonna need y'all to hop on over here to Norfolk County and come tell this jury what y'all did, because everything y'all are saying is exactly what we've been saying all along. The prosecution, of course, did not want to call them. They did not want to have any kind of testimony from them because none of their findings supported anything that they said. So of course they're not going to call them. But we have affectionately referred to them as the crash daddies because we have a thing with, like, we call it, like, you know, there's report daddies, and of course I'm married to chat daddy, and we have it's a thing. It's a thing. But they are affectionately known as the crash daddies. So the Commonwealth this time, the prosecution has brought in their own version of crash daddies. Different company. It's Aperture Inc., I think is what it's called. So it's kind of like the biomechanical engineer, same type of background, same type of company, but different results. So they have brought them in. So that's Dr. Welcher. That's the one that he's been talking about. So they present this. Brennan's like, hey, here's our dude, and here's all of our discovery on him and his findings and his reports. And then the next month is when the feds were like, oh, by the way, we're done now. So if any of y'all want to, use ARCA, now you can contact them. Now you can have open communication. Now you can do whatever you want to, you know, obviously anything that's under seal, they're not allowed to talk about, but if y'all want to engage with them, you can. So that was the month after the prosecution's, you know, new Crash Daddy stuff was turned over to the defense. So now they are like, okay, well, now we have all of this information. Let me give this to ARCA. We may potentially use them now that we can to, you know, rebut some of this stuff or give different opinions of some of this stuff or whatever. It is very, very common for if there's an expert on one side saying something and an expert on the other side saying something totally different, both sides will give their expert, the other experts report, opinion, whatever, so that they can see it and kind of be prepared to talk about it, because that is going to be stuff that comes up on cross-examination. So that stuff is totally normal. What Jackson is saying is we don't have anything else that he's given us because of that. We gave him all of this stuff from the prosecution's Crash Daddy. We turned it all over to him after we found out that we were allowed to have communication with him and allowed to engage him. We gave him all of that stuff, but we don't have any other reports or anything from him or from them, I should say, from ARCA, based on that. But if we get something within the next week to 10 days that we can actually use during the trial, we will turn it over as soon as we get it. So that's kind of the arguments on both sides with this one. It is disingenuous to talk about discovery deadlines when none of the discovery deadlines from the prosecution were met in the first trial or this one. So that is one thing that kind of like, are we really going to like, hello, Sally Port videos, you know, like, you do you not remember that? Like this thing on you, Sally Port, remember? But you know, whatever. So that's that argument. What else we had? Let's see. The independent reader thing. What do y'all think of for that one? Let's do a poll on that, because I'm curious to see what y'all think on that one. The independent reader thing is weird for me. I don't start a poll. Should they have an independent reader for the text? Tell me what y'all think about this. I'm curious to see what y'all say, because for me personally, this doesn't seem like a good idea for me, because I feel like the person who is testifying about the text being there. Now, look, if the person is here and able to testify, then yes, they'll have them read their own text. You know, they go through it. We will never forget, for those of us who watched the first trial, we will never forget Brian Higgins up there talking about, you know, weed whacker, and they will read their own text if they are there. The weed whacker thing is burned into my mind for the rest of eternity. But if they are not there, Brennan is saying he wants somebody to come in and read them. To me, it seems like unnecessary theatrics. I think that I do understand what Jackson's saying too, having, you know, you don't know who's going to put inflection into things that shouldn't have inflection. You know, I don't think it's a good idea. I think it just creates more theatrics that the last thing this trial needs is theatrics. We got plenty of theatrics to get us through on this. There's plenty of drama without bringing in actors or voice readers or, you know, anybody. So I personally don't think it's a good idea, but y'all tell me what you think. I'm curious to see. I listened to both arguments on it, and I think the defense's argument was stronger on why there shouldn't be one, and the prosecution's argument on why there should be just kind of fell flat with me personally. I don't see the need for it. But Y'all tell me. I think more emotions will be put behind the text, making it more than what it should be. That would be something I would be worried about as an attorney is, what if things are read in a way that is not meant for it to be read? I think it's up to the jury to read it and like the whole monotone, reading of text messages, it can get kind of tedious in some trials, but I think it's important because we can't put emotion or inflection behind texts that are read in court because we don't know the emotion or inflection that is implied behind text. So, okay, Wonder Kim says they would need Ben Stein to be the reader. Look, I will change my mind if it's Ben Stein. If they bring Ben Stein in, I'm all for it. He's the clear eyes guy. Like, clear eyes, dry eyes. Yeah, if he did it, there ain't gonna be any inflection or emotion. So if Ben Stein did it, I'd be good with that. Maybe the lady that says you are unmuted. She'd be a good one too. You are unmuted. I could see that one too. When Ben Stein's money. Oh my gosh. Forgot about that one. Bueller. Brennan's main tactic is theatrics. He's obviously trying to create more distraction from the fact that they don't have a case. He is very theatrical, and that is definitely part of his whole spiel. And it works with some people. You will notice that there are some things that he says, even if it's proven to be not accurate minutes later, it works. And that the fact that people will take it and run with it shows that it works, right? Like, I mean, so if it works with people online who even have the option to watch it and rewind it and then see that it was, cleared up or debunked or whatever, if you're running with it anyway, it obviously works, right? So the jury won't even have the option to go back and rewatch or have other opinions on it. They're just going to take it. So it is definitely a strategy. That's why I say that he tries this case as if he is trying it as a defense attorney instead of a prosecutor. His tactics. So I don't know. What else? Okay, that was the independent reader. The Dr. Crosby thing. So let's talk about that. Judge Kennedy said she will not reconsider him being an expert, will not reconsider that he can give his opinions. But saying that, the bite marks may or may not be Chloe, that's the part she has an issue with. I'm glad because that has been discussed. There's a show on Netflix, maybe, Wrongfully Accused, I think, or something like that. And they talk about, there's one episode that they have where it talks about bite comparisons and how that has been used to convict people and wrongful convictions. And how there's been so much information on it that has come out in recent years, like kind of calling it junk science, like you can't really, and keep in mind too, okay, he's saying that you can, Brennan is saying that you can exclude Chloe. But here's why that's a tough argument to make, because, all right, the whole thing is they're saying that it's on the arm, right? Okay, here's my arm. This will be different if I'm putting my arm up to defend myself. And I'm not saying that it is or isn't dog stuff. That's not my expertise. I know that Lucy is innocent of all charges. That's all I can give you as far as dogs go. But if I am being attacked and I put up my arm, it's like skin moves. Skin moves depending on how you move. skin is not like a flat plastic thing that you can put your mold like teeth into. Like that's not how skin works. And dog's teeth, what was that study that they talked about before, like or dog's teeth, will shift over time or whatever, but I don't know enough about that to give any opinion on that part of it. What I do know is that your skin moves. You're not going to have the same, like if the same dog bites you in two different spots on your body, you can't tell if it's the same dog by looking at it. You know what I mean? Like it could look like two totally different bites based on the angle they came from, or the, how hard they came at you, or how your body was positioned, or if the one part of your body was more fleshy than the other, or whatever. So it's just not reliable science. And I think that anything that's not reliable science is confusing to bring in. So I just, that part specifically, I just don't think it should be allowed. Also, the thing he said, what was he, what did he say? Hold on, let me look at my notes. Oh, and unless he said Crosby used a mold but didn't use an overlay. And according to that study, you have to have a mold and an overlay to be able to give any kind of opinion for that. So I don't know. But the judge said it's going to be an uphill battle for him to be able to get that in there. Yeah, see, Julia says my dog's teeth have definitely shifted with age. So yeah. I just think it's junk science, and I think that anything that's not reliable science, I just don't think should be part of the whole ordeal. Yes, the
Court is back in session. You may be seated.
victim of Chloe.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay.
Work.
All right. Were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay. Can we address, is it something you need for your opening?
It's not.
It's
Okay. All right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay. So now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor.
All right, this is
Okay.
one for sequestration for Turtle Boy, to keep him from being in the courtroom because he's on the witness list
Can we
when
have that?
Brennan is. What could he even call him for?
All right. I probably have it here too. I have one, Jim. Thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradel. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradel.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was, I'll hear you, Mr. Brennan. And you.
Oh, I'm sorry.
But that's okay. I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
No love lost there. Okay. So that is Bradel. That is one of Turtle Boy's attorneys. So here's the thing. They have Turtle Boy on the witness list. They ain't gonna call him. They ain't gonna call him. And here's the thing. Turtle Boy has pending charges for alleged witness intimidation for witnesses in this case. If he gets up there, and that's what Bradle's saying, if he gets up there, he's gonna plead the fifth. He's not going to say anything that can be used against him when he's got pending charges anyway. But also, the calling of him as a witness is a little, how can I say this? I think it's BS, honestly. I think it's BS. Here's the thing. If there was any kind of evidence about Karen Reed hitting John O'Keefe, it wouldn't be in Turtle Boy's phone, who started covering this much later. This is, to me, it felt more personal than anything. And as soon as I saw him on the witness list, I said, that's an attempt to keep him out of the courtroom. Because he's loud. Turtle Boy's loud. He is opinionated. He is aggressive. They don't like him. And he's given them no reason to like him. He is very, very critical of them. And he is aggressive about it. So, of course, Brennan doesn't want him in the courtroom. The fact that he's going to plead the fifth shows, I mean, like, if you know he's going to plead the fifth and he's not going to say anything, then you're not going to call him to the stand anyway. So that's what, and his attorney Bradle said, you know, he'll plead the fifth on his behalf. And Brennan's like, no, Turtle Boy needs to do it himself. I want Turtle Boy to do it. So he's about to plead the fifth. The reason that they're saying that they would potentially call him as a witness is for consciousness of guilt, because he says any kind of communications, if you remember, we watched that hearing together, if there's any kind of communications that he asked for communications between Karen and Turtle Boy, and Turtle Boy said on Twitter after that any communications that he had were all in Signal, an encrypted app. So they wouldn't have access to that anyway. And so he's like, that, you know, there's nothing there that they could even use. Like there's nothing that would, how do you show consciousness of guilt, you know, with a defendant talking to someone covering the case? It's just, it was always kind of a reach for that. Now, the judge has said if she allows Turtle Boy in the courtroom, for it, and remember, that's still even if he gets in for these, you know, with this randomized jury or randomized journalist thing where they're picking 10 randomly each week. That's it. So if he even gets in, that he will be allowed in, but they'll do what they did last time. So last time, what they did is any of the witnesses that were testifying that are part of the pending charges that he has with the witness intimidation stuff, he can't be in the courtroom from them. So like Jen McCabe, for example, like any of the ones who are listed in his alleged witness intimidation charges that are pending, if they take the stand, he has to be out of the courtroom. That's what they did last time. So that's what the judge is saying. You know, if she allows him in and he's not subject to the sequestration order, then it'll be pretty much the same thing. So we'll see. The crossover episode is insane lately. Isn't it crazy how the you know, ones reporting on the story are becoming the story so often? It's crazy. Yeah, they think that Karen Reed was giving Turtle Boy information. It's confidential and having him intimidate witnesses. What are the implications if Turtle Boy pleads the Fifth, but then talks about the case? They will say he waived the Fifth Amendment. There's some type of trap there somewhere. Yeah. So the way that the law is written, because we heard about this with Karen Reed waiving her attorney-client privilege when Brennan was wanting the text between her and Yannetti. If she, or if the defendant, not just she, that this is, it came, I'm saying she because it came up with her, but if the defendant talks about those communications, then that is, as it's written in the law, can be, waiving the right to the privilege. However, this specific thing wouldn't fall under that same thing, because this would be, because they're saying that this is like anything that he says can be used against him in his own proceedings. And they have like clips and timestamps and all that stuff from, his shows or whatever. And so any of that stuff can be, but as far as consciousness of guilt for this trial, what could you use that says consciousness of guilt, from anything that he's said? The consciousness of guilt thing is a tough one anyway, because so many people react to things so differently. Saying that you're having, their basic allegation is that, Karen Reed is having Turtle Boy say certain things and, harass witnesses and do all of these things, and that shows that she's guilty. Okay, but you could also see the flip side of that, and the argument could be, if she is being framed and she's mad, she is telling a journalist who she knows, believes her and, is spreading the word and, using his platform to say what he thinks about what's happening. So I don't really know that that's consciousness of guilt. Consciousness of guilt is a hard one to, for those kind of gray areas. Now, there are some things that are consciousness of guilt that I'm like, oh yeah, that shows, but we've seen that in different trials that we've watched together. But this one seems like kind of a stretch with that, but y'all let me know what you think. The use of signal looks really bad in my opinion. It's funny you say that, because I thought the same thing. And then yesterday, my husband was texting some of his friends and he was using Signal. And I was like, I've never actually even seen it. And I was like, you're using Signal? And he's like, yeah. He uses Signal because it is encrypted. And he's like, yeah, that's what any of like his special forces, buddies, that's the only thing they text in. And I was like, actually, if we all use Signal, it would prevent a lot of those uncomfortable weed whacker texts being read in court. Could you imagine some of the stuff in your text messages being read in court? Not me. Not me. Mandy Wright says, I use Signal. A lot of people do. Yeah, a lot of people do. I had never heard of it until this case, but I am also not a tech person. Like, tech is not my jam. So all that kind of stuff I didn't know anything about, but I didn't realize, there are a lot of people that actually use it. So I never heard of Signal. I'd only heard of WhatsApp. I've heard of WhatsApp too. I think I have it on my phone. Maybe. Does it automatically come on your phone? Or maybe I have it for something. I think I've seen that app, but I don't use it. Me and my work partner used to use Signal to talk about people we worked with. That's funny. A lot of government agencies use Signal for communications. Yeah, that's what the hubby said. Is he's he's military special forces, so he is like spy and stuff, like all the crazy stuff. He's got some crazy stories. But yeah, all of their communications are done through Signal. Who in this case used Signal? Karen Reed started using it to communicate with people, I think after they took her first phone, right? Which also is, you could say it's consciousness of guilt. I say it's smart, because if they've already taken one of your phones and then you get another phone, I'd be thinking, like, I should start using that. I'm about to download it. Have the husband teach me how to use it. Sometimes I post things on Facebook to only me. I want that to stay between the FBI and me. There you go. Oh, Mildred says, yay, Chat Daddy. My son served in the Army for 10 years. Now he's with the Department of Defense. Just got back from a special assignment in Germany. Well, thank him for his service. If Signal is consciousness of guilt, so is pleading the fifth. That's a good point, Marco, because a lot of people will say that pleading the fifth is consciousness of guilt, and it's not. And there's actually, that's part of jury instructions, that knowing that a defendant, like if a defendant chooses not to take the stand, or they plead the fifth, or whatever, they choose not to say anything, it's part of the way the law is written that you're not supposed to read into that at all. When I did that interview with Reb Maisel, one of the things that she said about that was, that's like law school. She said her very first day of law school, she was calling her family, like, if you ever, have any kind of run-in, you don't talk to anybody, you get an attorney immediately. Like, that's like law school day one, like first moment of the first class, like, don't say or do anything without a lawyer. And anything that you say can and will be used against you, even things that you don't think are something that could be used against you, or it could be the truth, but the way that you say it could be whatever. You just never know. And it is always better to have representation, because it doesn't show that you're guilty. It shows that you're smart. Never talk to anybody without an attorney. Ever. Tegan says, I use Signal so I can discuss government conspiracies. It's a good reason. It's a good reason. Peter says, if you're guilty, get an attorney. And if you're innocent, definitely get an attorney. True. True. Especially because think about how many times we've seen, like, I have become very, very interested in wrongful convictions and things like that, because it's so heartbreaking. And, some of these people that have lost decades of their lives for things that they didn't do, that is just heartbreaking to me. And it affects so many people. And then that's not justice. Somebody behind bars is not justice. The right person being held accountable for what they did is justice. But just somebody being accountable is not. And that's something I've been getting more and more into the last couple of years, especially. But you see some of the things that in a lot of those cases, like where the officers will just get tunnel vision, and there's a lot of pressure on them, especially in, big cases. There's a lot of pressure on police to close the case, to get answers, to get justice. And I think sometimes it's instinctive for some people to have that perception that justice is somebody getting held accountable, but it might not be the right person getting held accountable. And that's very different. So I think that's why it's important to have an attorney. I don't think that that's a consciousness of guilt thing at all. I think that that's the first thing you should ever do. Protect yourself, protect the truth. Country Frog says working on 2 exonerations in Florida now. It's sad, isn't it? Signal was used. Oh, the director invited Jeffrey Goldberg into classified Yemen attack plans. So yeah, so it's used a lot. The case of Adnan Syed. That was the very first podcast that I ever like really listened to, and I got so into it, and I was like all I wanted to do was listen. Every episode, I was like hanging on to every word. I'd be listening to it in the car, and then I'd get to work, and I'd be still sitting there like, wait, I need more information. That's a sign of a good podcast, though, when you're hanging on to every word and you don't want to get out of your car. Alyssa K says, spending most of my days in a max prison. Trust me, you want to be sure that the right people are getting sent there. Yeah. Yeah. If you want a trip to Crazy Town, the Lori Dumbbell trial is the place to be. Oh, gosh. That was the very first trial I ever streamed. The first one. Kelly P says, that's how I feel when I listen to Conspiracy in Canton. Thank you. Thank you. Amber says, I'm at work now listen to your podcast while I'm driving. I just listened to the one about Karen's trial yesterday, which brought me here. Well, welcome. Welcome. This is going to be an interesting trial, y'all. It's going to be so different than the first one, too. Didn't they say 10-minute break? What's taking so long? We need them to come back.
You are unmuted.
Whew. It's like I ask and they listen. All right, we ready?
Court is back in session. You may be seated.
All right, Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Kearney that he would, in fact, invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Kearney to for his Fifth.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel.
Thank
And
you.
all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
Why won't he let his attorney invoke the Fifth Amendment right for him? Why is what? Why? Theatrics. Theatrics, I tell you. Brennan cannot give up any control. It really does feel like that sometimes, doesn't it? Yeah, that doesn't make any sense to me. Like, since when does your attorney not, whatever. I mean,
Tori, Jim?
Yes.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege, and I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the 2 minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way that where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy and
it is something that we've done.
right. Understood. I would like to see what I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, so the court, please.
all right. All right. Well, that's it. So he will be allowed in the courtroom. He is exempt from the sequestration order, except for during the testimony of those witnesses who are listed in his pending charges. So that's that. So she didn't actually, well, she did rule on that one. She did rule on that one. And they agreed during that break that the findings from the internal affairs stuff, the findings from like Proctor and Tully and who else was it? Buchanan were able to be brought in, but they did not agree on Kevin Alberts. So at least there was an agreement on that one. The rest of them, she said some of them she's going to have rulings for tomorrow. So we'll keep an eye out. I'm going to end this poll so we can see where we're at. All right, so I said, should they have an independent reader for the text? 76% said no, and 23% said yes. So I can't believe we're in the final stretch. We are almost there. We're almost there. Almost, so close. So close. we have no court again until Tuesday. So y'all rest up this weekend, because starting on Tuesday, we are going to be so busy, and it's going to be a wild ride. The first the first trial was like, I think by the end we were all just a little little emotionally unstable towards the end of it, but that's okay. Tuesday though, we'll be fresh faced and ready after a few days off. Beth says, I cannot wait for this trial again. It's gonna be interesting. It's gonna be very interesting. All right, so I will have a recap out. Oh, they didn't say the time on Tuesday. I'm assuming 9. I think that's what was on the docket when I looked last time, but I'll double check. But we'll have the stream up and ready before Tuesday, so that y'all can hit notification to make sure that you don't miss it, because we want to make sure that we're there on Tuesday. That is going to be a big day, because we're going to get to hear the openings, and the openings will set the tone for the entire rest of the trial. Remember, this is going to be kind of how everything is laid out. Look at the openings from the last trial, for example. Lally got up there and he listed, I can't remember, I put it in the podcast how many names it was. He basically read off the entire witness list. And it was not engaging, and it was monotonous, and it was difficult to follow. It was not effective, in my opinion. And it didn't give any kind of blueprint as to what the evidence will show. It just gave a blueprint as to which witnesses are going to be called. And then that's kind of how a lot of the trial went too with the prosecution last time. There wasn't a lot of structure to how everything was presented. And it was just kind of, I mean, it was basically presented like in chronological order. It's like, well, first we'll call, first they called his brother and his sister-in-law. But then everything after that was like, okay, well, then it's the first responders, and then it's first it's like the Canton police, and then it's the, fire and rescue, and then it's the waterfall people, and then it's the, I don't know. It was like groups of the witnesses, and he just kind of went down them, but it didn't give the jury a cohesive story. Like, how far were we into trial before they even heard for the first time anything about the prosecution's theory about what happened? It just wasn't organized in a way that was clear for the jury to know what to listen for and what to look for. The defense was very different in how they came about it, because you remember, like, the very first thing Yannetti said in his openings was like, Karen Reed was framed, and he laid out kind of what he's wanting the jury to pay attention to, and what he says the evidence will show, and what to focus on. That set the tone for the whole rest of the trial. So on Tuesday, we're going to have 2 different attorneys giving the openings this time. We'll have Alan Jackson doing the defense this time, and we'll have Hank Brennan doing the prosecution this time. So it's going to be 2 totally different styles, 2 totally different attorneys, 2 totally different openings. And we've already heard Brennan say today that, he's going to have a clip of an interview from one of Karen Reed's interviews that he's going to play. We didn't hear anything from the first trial about any of her interviews or anything that was said in any media stuff that she had done. So it's going to be very different. And Tuesday will set the entire tone for all of that, and kind of give us, because that's what they do. They say the evidence will show you know, this and this and this. This is what you're going to see. This is what we're going to be showing you. So we'll see. And that'll be Tuesday. Day one is Tuesday. Openings on Tuesday, and then we'll have 84 years. 84 years. Are we going to have subscriptions by Tuesday? I don't know. That's up to YouTube. Sometimes quickly, sometimes slowly. It took forever for them to do my channel. This weekend you can catch up. Yep, catch up. Get all the info. I will have a podcast episode out within a couple days of kind of everything that has gone on this week. And then Tuesday, it's going to be a big day. And I'll have a recap video later today. I should have a recap video just kind of quickly going over what happened today as well. Quick little breakdown, summarize it. So that way, if you zoned in and out, or if you had to actually go be an adult for a while and then come back and you miss something, that way you don't make sure you don't miss anything. All right, y'all, I appreciate you so much being here. If you have not hit subscribe yet, make sure you do that. Hit the notifications so that you never miss it when we go live. And we will see you on Tuesday. All right. We're almost there, y'all. I appreciate it. I'll see y'all soon.